group are responded to positively.
Amendment proposed in clause 18, page 21, line 30, after implementing, insert terms of service.
My Lords, my noble friend on the front bench has said at various points in the course of our committee, when we were in committee, that the bill struck an appropriate balance between protecting the rights of children and the rights of those wishing to exercise their freedom of expression. I have always found it very difficult indeed to discern that point of balance in the bill as originally drafted. But I will say that if there were such a point, it has been swamped by the hundreds of amendments tabled to the bill since our committee met by my noble friend, which push the bill entirely in the opposite direction. Amongst those amendments, I cannot find, and it may be my fault because I'm just looking myself, I've got no help to find these things. Amongst those amendments, I do not find a single one which seeks to redress the balance back in favour of freedom of expression. My amendments 123, 128, 130, 141, 148 and 244 seek to do that to some extent, and I'm grateful to the noble Baroness Lady Fox of Buckley for the support she has expressed for them. Now, the bill includes various provisions requiring providers to have regard to freedom of speech. The group of amendments I'm about to speak to address the fact that nowhere in the bill is there any obligation placed on Ofcom to have regard to freedom of speech, unless, I say, it is just possible, unless it is in that swathe of amendments that has been tabled, which I have been swimming in over the weekend, looking for a few pearls, but finding none. So I will take, noble Lords, very briefly through those amendments and say what they actually do, because really I can't see that there could be any objection to them from any member of the House, but it seems the government is uninterested. Amendment 123 imposes appears in Chapter 6 of the bill, which deals with codes of conduct, and it imposes a new duty on Ofcom in exercising the functions listed in that regard to have special regard to the importance of protecting the rights of users of a service and interested persons to freedom of expression within the law. Who can object to that? 128 requires Ofcom to issue a statement when it is issuing a code of conduct showing how it has complied with this new duty. 130 requires the Secretary of State to lay that statement before Parliament alongside the Code of Conduct, the draft Code of Conduct, when he lays it. 141 relates to how Ofcom responds to a direction. We're moving away from codes of conduct now. We're moving away to Ofcom's activities when they respond to a direction from the Secretary of State made under Clause 9. And it requires the document Ofcom submits to the Secretary of State in response to that direction to specify how they have complied with the new duty. 148 requires Ofcom to issue a similar statement to accompany minor amendments to a code of conduct. 244 imposes a similar duty on Ofcom in relation to the issuance of guidance, which again is separate from codes of conduct and separate from responding to a direction from the Secretary of State. Finally, 269, which is slightly different, relates to Ofcom's guidance to providers on enforcement activities, because Ofcom is required to give guidance to providers on how they conduct enforcement activities. And again, it requires Ofcom to have regard to freedom of speech in doing that. Now, these are not wild and woolly demands. One of the briefs I have received in relation to this to report stage reads as follows. It says the proposed duties on providers of Category 1 services that seek to protect freedom of expression should be replaced with a single comprehensive duty to protect the right of freedom of expression. This duty should require Category 1 service providers to take all reasonable steps to ensure that freedom of expression is not infringed by measures taken to comply with the other duties in the bill. This should include giving the duty to protect freedom of expression similar status and form as the duties on illegal content. That does not come from some strange right-wing think tank. It comes from the Equality and Human Rights Commission. And they go further. If I may briefly trespass on the House by quoting a little bit more, the duty to protect the right to freedom of expression should be included in the list of relevant duties for which Ofcom will be required to develop a code of practice. I think I've referred to it as a code of conduct in my remarks so far. Code of practice is, in fact, of course, the correct term. Precisely what one part of my amendments, is seeking to do. So, as I say, these recommendations have a very good pedigree. I cannot see for the life of me why the government would want to resist them. I will turn very briefly, before I sit down, to some of the amendments in the name of the noble Baroness Lady Fox of Buckley, to which I've added my name. Number 162 seeks to remove the offence of the Public Order Act, Section 5, from the list of priority illegal content. This is the provision in the Public Order Act which criminalises threatening or abusive words or behaviour or disorderly behaviour likely to lead to harassment, alarm and distress. We have spent in this House a considerable amount of time last year in relation to the Police Crime Sentencing and Courts Bill, seeking to get new guidance, which has subsequently arrived, statutory guidance, to the College of Policing about how, in the non-virtual world, this complex and difficult offence should be enforced. But here we are simply handing it over, in effect, to private companies, many of them abroad, under the sort of the strange and remote supervision of Ofcom, and we're assuming it's all going to work very, very well. It is not going to work very well. And the example given by the noble Baroness of transgender disputes is a particularly rich example of how difficult it is going to be to enforce this and for private companies to be enforcing it online. There is a very strong case for removing it from the bill altogether. I'll mention also briefly Amendment 188. This relates to Clause 65, which is about providers' terms of service. I simply ask the question, what it requires is that Ofcom enforces terms of service in a way that is compatible with our rights to freedom of expression under the European Convention of Human Rights. Remember, many of these companies come from countries that are not European. They do not live under the legal cosh, if you like, of the European Convention on Human Rights. Why should we be enforcing terms of service that might be perfectly legal in California or in Russia or in Kazakhstan? We don't know where the next most popular phenomenon on the website is going to come from. Why should we be enforcing their terms of service without having the restriction placed on Ofcom that they cannot do so in a way that contravenes or does not uphold our rights under the European Convention? And finally, I mention 275, Amendment 275, this peculiar discovery that the British Board of Film Classification is running its own parallel censorship system. They used to be called censors, so I think I can fairly call them censor, in an entirely private arrangement that has no supervision from Ofcom at all. And the suggestion is that perhaps if we're going to have one system supervised by Ofcom, everything might be brought within it so that we have a degree of consistency. Again, I find it very hard to understand why the government would want to resist an amendment that is so pellucidly commonsensical. So, with that, my lords, I will sit down. I do not think these issues are going to go away. There is a very strong public interest in this, as there is increasingly, in fact, in recent days, in various other amendments that are going to come up later in the bill. It may be that we think that by pushing it through in the way that we have with the amendments the government has conceded to those arguing for stronger enforcement and more restriction on access to the internet, that it will all pass through the Commons and simply become law. I seriously have my doubts, as I have expressed in relation, for example, to Wikipedia and the threat to Welsh Wikipedia, whether some of this is going to survive first contact with reality. The amendments I'm proposing would, in my view, make it easier to do so.
If I could